online to our webpage at pickofdell.org. And then Stephanie Ramirez is our co-presenter today. And Stephanie, you want to talk about the Disabilities Law Program?
Sure. So the Disabilities Law Program is the protection and advocacy system for the state of Delaware. And this is a designation by the governor for advocating on behalf of individuals with disabilities in a range of different ways. And so what we do is we provide free civil legal services to vulnerable and underserved Delawareans, including individuals with disabilities. We engage in individual and systemic advocacy. So individual advocacy would be like on an individual case-by-case basis, and then systemic advocacy when there's a large issue affecting a lot of people. And then we also provide information, referrals, and technical assistance. And just like PIC, we are located in all 3 counties as well. We have offices in Wilmington, Dover, and Georgetown. So this is kind of an overview of our series this month, all about discipline. So the one today is the overview of discipline, special education, and IDEA. And then the one next week, Thursday, 12 p.m., will be all about manifestation determination reviews. And then on the 24th, at 12 p.m. Will be all about restraint and seclusion.
So the learning objectives today, we're going to talk about how to identify how disciplinary removals differ for students with disabilities, which is called the 10-day rule. Explain what constitutes a change of placement, name some of the effects of disciplinary removals on students, and then we're going to also talk about instances of informal removal. So Stephanie, you want to talk about the law?
Sure. So one of the federal laws, right, that gives students the right to special education is the Individuals with Disabilities Education Act, or IDEA. And then on here is the statute, or the actual law where that can be found. And then the regulations are the rules that kind of go through how exactly the law should be implemented. And then in Delaware, we also have an equivalent law. It's called Exceptional Children. And throughout the presentation, there'll be mentions of both IDEA and exceptional children. And then the information for where you can actually find the law and the rules is also included on this slide. So what, in particular under IDEA, we'll be talking about Part B today. Part C covers birth to the age of 3. And IDEA Part B specifically covers children with disabilities who are age 3 up through 21 inclusive, which at least here in Delaware, children with disabilities who are eligible under IDEA can continue to receive services up through the end of the school year in which they turn 21, or up until they receive a high school diploma. And the purpose of IDEA is to make sure that children with disabilities have available to them a free, appropriate public education. And that is with special education and related services to meet their unique needs, and that prepares them for further education, employment, and independent living. And so one of the hallmarks of IDEA is in the name, individualization, right? It's every child is different. And so the education needs to be designed to meet their unique and individual needs. And then IDEA is also there to protect the rights of children and their parents, help make sure that schools and the government can educate all children with disabilities, and make sure that the education that students with disabilities are receiving is effective. And so if a student is eligible under IDEA, they'll receive what's called an IEP, or an individualized education program or plan. And it's a document that lays out their entire program and kind of what they're receiving in special education and related services. And it's everything that's in there is what the student needs in order to receive that free, appropriate public education. And then in addition to the IEP, there might be some additional attached documents that go along with the IEP. And that could include either a behavior support plan or behavior intervention plan. It could include a safety plan or a crisis plan, a health plan, or a contingency plan. So the behavior support plan and behavior intervention plan specifically talk about maybe some target behaviors that a student might have, and different ways that staff can address those behaviors if they see them. In terms of a safety plan or crisis plan, that might be something like if a student is a danger to themselves or others, or if there's an escalation that happens with a student's behavior, that'll actually outline kind of what to do in that case. And then the health plan could be something like if a student has allergies and needs, and that just needs to be documented in there. And then the contingency plan is something new that the US Department of Education had talked about in their return to school roadmap. And that would be a plan for how services can be provided in the event of a school closure. And so that might be something to look into. And we have the series that we did last month talks about contingency plans in there if you want some more information. So in addition to IDEA, Section 504 of the Rehabilitation Act also provides protections for students with disabilities. This is not special education. What Section 504 is an anti-discrimination law that's designed to protect the rights of individuals with disabilities. So not just students, this is all individuals with disabilities. In accessing programs and activities that receive federal financial assistance. And so why this applies to schools is they receive federal financial assistance, at least public schools. They receive federal financial assistance. They receive money through the funds with IDEA and in other places. So all public schools have to follow Section 504. And one of the things that it requires is that local education agencies, or LEAs, which are the school districts, they provide FAPE to eligible students. Now this FAPE is different than the FAPE that is required, the free appropriate public education that's required under IDEA. And we're going to get to that on the next slide. But what follows is just where you can find the law and the rules for Section 504. So if a student qualifies for a Section 504 plan, what that is that's the document that lays out all of the services, supports, accommodations, modifications that a student with disabilities might need in order to receive equal access to education. And this is different than the special education and related services that a student might get under the IDEA. So the FAPE in this context, the free appropriate public education is regular or special education designed to meet the individual educational needs of students with disabilities as adequately as the needs of students without disabilities. So it's not necessarily changing the curriculum or changing what's being given to the student. It's more about changing the environment or maybe providing some additional accommodations or modifications on assignments, right? So this would be something like if a student had ADHD and needed extra time on assignments, that might not be a disability that would qualify under IDEA, but it would probably be something that could qualify under Section 504, and that could be just some increased time on assignments. And so it's not individualized curriculum or instruction, but it may include some behavior supports and behavior plan if the student needs that in order to have equal access to their education. And so here's just a brief recap of the difference between an IEP and a Section 504 plan.
There are many differences between an IEP and a 504 plan. The first and most fundamental is they're governed by different laws. An IEP is governed by a special education law. 504 is governed under a civil rights law. And that makes a difference in what kinds of services and how an IEP plan and 504 plan come together. To qualify for an IEP, you have to have one of 13 specified conditions or disabilities that are written in the law. For example, specific learning disability, which would be something like dyslexia, would be a condition that a child would qualify for an IEP under. Having one of those 13 identified disabilities isn't enough to make sure your child gets an IEP. Whatever is going on with your child, whatever that disability is, also has to affect his performance in the classroom. And that's really important to know, because sometimes parents think that just having a disability qualifies for an IEP, but you also need to make sure that it's making a difference. It has what's called educational impact, adverse impact in the classroom for how your child's learning. For a 504 plan, a child needs to have a disability that is getting in the way of his learning in the general education classroom. The difference isn't that he needs specialized instruction, it's that he needs some changes to get benefit from his education the same way as other kids in that classroom. And so kids who have ADHD often have 504 plans, and what happens is just changes are made to the environment, and those changes are called accommodations. And those changes are made in the general education classroom and don't require specialized instruction. So for example, a child with ADHD may need extra time to work on a test or to get his homework done. So some people are concerned that a 504 plan isn't as good as an IEP. And the truth of the matter is that a 504 plan or an IEP can meet your child's needs. It just depends on how well it's put together. A well-written, well-implemented plan that everybody knows what's going to be happening and in place and is working on it can be very helpful for a child who doesn't need that specialized instruction. As long as there's a lot of follow-through and everybody's checking in to make sure it's working well, a 504 plan can be very helpful for kids in the classroom.
Key takeaways. An IEP is governed by a special education law. A 504 plan is governed by a civil rights law. A 504 plan covers kids with disabilities who don't require specialized instruction.
All right, so now that we have kind of the background on special education and 504s, we can get into the meat of the presentation and get to the fun, the discipline. So one of the things that provides for standards in the school environment is the district codes of conduct. Each district has their own set of codes of conduct, and they generally set the standard for the behavior in the classroom or even at like a school function. The standards for dress, academic integrity, and that is around cheating, plagiarism, standards for attendance, and then more recently, there are standards around bullying. And then they also include those consequences for violating the standards. And the thing about the district codes of conduct is they apply equally to both students with and without disabilities. But this is a big one. IDEA and exceptional children, right? So the Delaware law provide additional protections for students with disabilities who are facing disciplinary action. So they violate a student code of conduct and are then facing disciplinary action. What students with disabilities can take advantage of are called the procedural safeguards. So what this requires is that before the school can take certain types of disciplinary actions, the relationship between the student's disability and the specific act of misconduct has to be examined and looked at. So they have to take account of whether or not that child's disability actually had any kind of effect or was the cause of that behavior. And one really important thing is that students with disabilities have to be served, they must be served in the least restrictive environment. And that least restricted environment is where they are able to get the benefit of special education and related services. So if they can take advantage of all of that and be served in the regular general education classroom, then that's their least restrictive environment. But if they need a different setting, or maybe they can't be served for the full day in the general education classroom, then that would be their least restrictive environment. So what the procedural safeguards say is that before any decision is made concerning a disciplinary change of placement, so taking that child out of their least restrictive environment and placing them somewhere else for disciplinary reasons, when they're in certain instances, the school has to then hold what's called a manifestation determination review. And the next couple of slides are going to give some really general information about manifestation determination reviews, because our session next week on Thursday is going to cover this in more detail. So I just want to provide a little bit of information now, and then next Thursday, if you join us, you can get some more detail on it. So in terms of manifestation determination reviews, the meeting itself must be held within 10 school days of any decision concerning a disciplinary change in placement. So if a decision is made by the school that they're going to suspend the student, that meeting must be held within 10 days. And the MDR team, or manifestation determination review, the team that's there to talk through whether or not the behavior was a manifestation of the student's disability, is the parent, the LEA or the school district, and any other relevant IEP team members. And that might be the school psychologist, it could be the general education teacher, the special education teacher, the nurse, anybody who would be relevant to making this decision. And when we talk about change in placement or change of placement, it's a very specific definition. So it's any removal of more than 10 consecutive days from the least restrictive environment. So if a student, the consequences is a suspension and the suspension lasts for more than 10 days, that would trigger this. That would be a change of placement. But that's not the only type of change of placement. The one that we probably see more often is the second one, which a change of placement can be a series of removals which constitute a pattern. So that would be something like if a student exhibits the same behaviors more than once and it has been suspended for that same behavior, and now we're getting up to 10 days, that would probably or possibly be considered a change of placement. So here we go, right? Paul, a student with an IEP, is facing a 3-day suspension for fighting. This is his first suspension of the school year. So Paul, hasn't been suspended before. School year, 3 days. Do you think that this is a change in placement? No. And feel free to type it in the chat if you think it is or isn't. I don't have a poll, but I'd love to get some interaction. I don't want it to just be me talking the whole time. Yeah, so Tina, what do you think? Is this a change in placement? And Brian says no, hasn't met the threshold. Eliza, no. All right, yeah, let's see whether this is. No, it's not, right? So it's 3 days, right? There's no, hasn't met the 10-day threshold, like Brian stated. All right, so here we go. Paul, he's back. A student with an IEP is facing a 3-day suspension for fighting. He's already been suspended for 8 days this school year for similar behaviors. Is this a change in placement?
Yep.
Yep. Hear Diane saying, yep. Laura, yes. Brian, yes. All right, let's see. Maybe. Oh no. Let's see. So it's maybe a change in placement because it depending on depending on the behaviors, right? It says that it's similar behaviors, right? But what's actually going on? Will a manifestation determination review need to be held? Definitely. Will the team determine that it actually is a change in placement? It's not sure. Probably. But yeah, I think we could generally agree that it would lean to the more yes side of maybe. So a little bit more information about the actual meeting itself is, so it's to determine whether the conduct was either caused by or had a direct and substantial relationship to the student's disability, or is the result of the LEA, the school's failure to implement the IEP. So even if the behavior itself the action itself was not caused by the student's disability, if the school failed to implement the IEP, that could potentially be a manifestation, because if there was a failure, if the student didn't have the supports they needed to be able to not have to resort to maladaptive behaviors. And so if the behavior is a manifestation, then the student must be returned to their LRE. They have to be returned to their least restrictive environment, and they have to receive some additional supports. Possibly a functional behavior assessment to be conducted. If they have a behavior intervention plan already, maybe it needs to be updated. If there's not one already, then one should be put in place. Like I said, this is really brief. We'll get into more of what actually those things are when we talk next week. But if the behavior is not a manifestation, then the student's disciplinary change can proceed. They can be suspended for that, past the 10 days or whatever the disciplinary action is. But additional supports have to be put in place. And that goes back to functional behavior assessments, behavior intervention plans, and different things like that. So as the parent or student who's facing disciplinary action, there are safeguards if you disagree with an action of either the IEP team or the manifestation determination review team. So you can appeal by requesting a due process hearing, and the hearing must be held within 20 school days from the date of the hearing request. And the hearing officer has 10 days after that hearing to issue their decision. But the student has to remain in that other settings while the hearing is taking place. So if so if they're suspended for, if they're being sent for a 45-day placement, which we'll talk about when we get farther into the presentation, then they might have to stay there until the decision is made in the hearing. And I see Brian has a question. So if the behavior is a manifestation and there has been no FBA, is an FBA required? Or must the IEP team simply consider doing an FBA and or revise the BIP? So generally what they're required to do, and Tina, please correct me if, based on the document that for the manifestation determination review, and we'll show you that next week, an FBA is required to be done. And the IEP team must revise the behavior intervention plan if one is already in place, or create a new one.
Yeah, an FBA is the precursor to a BIP. Yeah. So if there's already a BIP in place, then it would be revised. If there isn't a BIP, an FBA would be required. And usually a team is going to want to, because what this says is that whatever behavior interventions are in place are not appropriately supporting the student if there is a need for a manifestation, and if it's determined the behavior is a manifestation, then the IEP team would want to have an FBA. I've never been in a situation in a manifestation where it was determined it was a manifestation and the team decided that they weren't. But by that point, there already is usually an FBA and a BIP in place. I guess the only time you might not is if, no, really, at that point, an FBA is probably the most warranted. And especially if it's determined that it is a manifestation because the school did not implement the IEP, because then you would want to know why, was the FBA, were the things put in place not available to the school, where like you would want to explore that. So yes, it's long-winded, but we'll talk about it next week as well.
So one other thing, one other procedural safeguard is that even for students without disabilities who are facing long-term suspensions or expulsions, parents can request an evaluation during that period. And then the district, if certain conditions are met, then the district has to do that in an expedited manner. So they have to do it more quickly than the normal process. And so it must be expedited if the district did not have knowledge of the disability, of a disability before the discipline, and the parent requests an evaluation during the period of the discipline. So if the school had no knowledge that this child could be a child with a disability, and the parent, while the student is in the middle of this long-term suspension or expulsion, requests that an evaluation be conducted, then it has to be done more quickly. But otherwise, it would just go through the normal evaluation process, which is 45, the school generally has 45 school days or 90 calendar days, whichever is less, or whichever is sooner, to conduct the evaluation and hold a meeting. But until the evaluation is completed, the student has to remain in the placement determined by the district. So until that evaluation is done, that student is still suspended or expulsed. Yes. If the student is determined to be a student with a disability after the evaluation, then the protections for students with disabilities will apply. So everything that we've been talking about, the manifestation determination reviews, and all of the other protections that come with being identified as a student with a disability, all of those will then apply to that student as well. If the district needs to conduct an evaluation, can the placement be in a more restrictive setting than the current setting? So it would be, if the district is conducting the evaluation, then the placement is whatever that placement is at that time. They can't then say, oh, we're gonna have you be in a more restrictive placement while we do the evaluation, right? Because that, arguably that could get into some murky waters in terms of why that student would necessarily need to be there and why that change is coming after an evaluation was requested. Yeah. Thank you also for the questions. What about students with disabilities during their period of removals, right? So if a student has been removed for 10 school days or fewer during the school year, then the LEA is only required to provide services to that student if they provide services to students without disabilities who are also in the same situation, who have been removed for less than 10 days or 10 days during the school year. So we're back with Paul. Always fighting and getting in trouble. Code of conduct requires that a student caught fighting should receive a 3-day suspension. This is Paul's first suspension of the school year. Is the school required to provide services to Paul during the removal? No, unless it also provides those services to students without disabilities who are removed for fewer than 10 school days. But if a student has been removed for more than 10 school days in the same school year, in any additional days of removal, so any days after the initial 10, then the LEA, the school district, must provide the student with a free appropriate public education, right? So all of those special education related services that are necessary for that child to be able to participate in the general education curriculum and make progress toward meeting their individualized and unique IEP goals. Here we go, Paul. Facing a 3-day suspension, which will put him at more than 10 days removed for the school year. So is the school required to provide services to Paul during the removal? Yes, for any removal days after those first 10. So if Paul had 9 days originally and he's going to add an additional 10, then that 10th day, they wouldn't necessarily need to provide services, but for the 11th and 12th day, they would. And then what about students who are not yet identified as being a student with a disability under the IDEA? So they can take advantage of the discipline-related protections if the school district, the LEA, had knowledge the student was a disability, student was a student with a disability before the behavior actually occurred. And that can be done in 3 different ways. Either the parent has at some point expressed concern that the student may need special education, and that's not to, that concern would need to be expressed not to like a custodian, right? Like that, it wouldn't necessarily give the school knowledge if it's being made to the teacher, who then, you know, relays that to the counselor or to the special education coordinator or director. Then that would show that the school district had knowledge. Or if the parent has requested an evaluation for special education. So the parent requests an evaluation, and you know, they might be in the process already of conducting the evaluation and going through this, and then the behavior happens. That would then give knowledge to the school district that, you know, they had that knowledge that that student might be a student with a disability. And then the other, the last one is if a teacher or other staff have expressed concern about the behavior and relayed that to, you know, like a counselor or somebody with like supervisory authority at the school. And then there are these special circumstances where the school doesn't necessarily have to follow the 10-day rule. And that is where the behavior of the student involves drugs, weapons, serious bodily harm to another person, and those actions occur on school premises, you know, while they're at school or even at a school function, if the school function is happening somewhere where it's the school or school district hosting it or one of their buildings. And then if it's one of those special circumstances where it's drugs, weapons, serious bodily harm, then the school district can immediately remove that student to an alternative placement for up to 45 school days, even if the student has a disability, and even if that disability, the behavior was a manifestation of that disability. But the maximum amount is that 45 days. So they can still remove them, but only for 45 days. So what we've kind of talked about are all of the procedural safeguards, right? All of the rights and protections that students with disabilities have when it comes to discipline at school. What we have seen or have noticed is that there are ways that schools can get around some of these protections. And so that's what informal removals are. And that's what we're going to be talking about a little bit now. So informal removal is when a student with a disability receives an off-the-book suspension. And it's because of unaddressed behaviors related to their disability. Another definition would be when a student with a disability is removed from school for a sufficient period of time to constitute a change of placement without the rights extended to them under the US Constitution, state or federal law, and or regulation, right? So they've had a change of placement, but what did they not have? Manifestation determination review, right? They didn't get any of that, but all of the removals that they have had it should be considered a change of placement. And these definitions are from the National Disability Rights Network. Recently published a new report on informal removals, and it's called Out from the Shadows, Informal Removal of Children with Disabilities from Public School. And so that's where these definitions are coming from. It's available free online, and we'll likely share the link. Actually, I can do that now, but we can share this also when we share the slides from the presentation. So what do informal removals look like in practice? So the last slide was like here's what it is, but this slide is, okay, show me. So if any of the following occur because of behaviors related to the student's disability. So shortened school days. A student is sent home at a fixed time every day. And this is going to be likely before the school day ends, right? I mean, every student arguably goes home at a fixed time every day because the school day ends at a certain time. But in this case, it's a student being sent home at the same time early every day because of their behaviors. Send homes, that would be where a student is sent home frequently in the middle of the school day. It occurs more irregularly than shortened school days, so it's not every day. But it occurs often enough that it can cause harm to the student. Homebound instruction. Student is placed on homebound with generally fewer than 10 hours of in-person instruction per week. And then virtual or remote instruction. And this is where they're placed on virtual instruction because of their behavior, even though everybody else is in person. So it's got nothing to do with COVID, has nothing to do with mitigating any disease or anything like that. This is because of their behavior. They are not allowed to physically be at school. They are required to do remote instruction. So here's Harper. She is a student with behavioral challenges who receives services under an IEP. School allows her to attend school only until 12:30 p.m. every day, even though the school day does not end until 3:30 p.m. Is this a form of informal removal? What do we think? Eliza says yes. Pamela says yes. Darnasia, yes. Lori, yeah. So yeah, it is. It's a shortened school day, right? She's sent home at a fixed time every day. She is sent home at 12:30 p.m. every day because of her behavioral challenges, even though the school day does not end for another 3 hours for everybody else. All right, let's see. Jason is a student with behavioral challenges, but does not have an IEP. Since the beginning of the school year, the school has called his parent to come and pick him up in the middle of the school day at least once a week, and sometimes every day of the week. Is this a form of informal removal? I know this one's tricky because he doesn't have an IEP, right? So is it still informal removal, even if he doesn't have an IEP yet? Laura says yes. Yes, because of child find. All right, let's see. Maybe. And Eliza has it, right? Child find. So he's sent home frequently in the middle of the day, right? Frequently. But why is it maybe a not necessarily 100% yes? Well, Tina, if you click it one more. I think, there we go. Right, we need to ask the question, does the school have knowledge that he may be a student with a disability? And that gets to Eliza's point about child find. Under child find, right, school districts are required to have policies and procedures in place to identify, locate, and evaluate students with disabilities who live in their in their district. And in this case, right, if Jason is possibly a student with a disability, then under child find, they're required to identify, locate, and evaluate him. And in this case, if the school had knowledge that he may be a student with a disability, then it's likely this is a form of informal removal. Brian, to your question, I don't want to say definitively yes or no, because there's not enough information, right? But generally, if the student is being removed from one classroom to another, and is receiving instruction differently than they should be receiving instruction, then it could potentially be an issue for the school. It could potentially be a violation. I would need more information about what's happening to give a definitive yes or no, but. Sorry, I can't be more definitive. So Angelica is a student with behavioral challenges and receives services under an IEP. Even though her school is providing instruction in person, the school requires that she participate in class remotely because of her behavioral challenges and not because of COVID-19 mitigation measures. Is this a form of informal removal? What do we think, Tina? Maybe. Yep. Even though students are back in person, she has to participate remotely because of her behavioral challenges. Not anything related to COVID-19, not anything related to anything other than because she's disruptive. It's informal removal. And Tina is gonna share some tips.
So if you suspect that, that it is a case of informal removals, you can do a couple of things. You can ask the district for their code of conduct. You can request an IEP meeting to talk about how the removals and, how many have happened, whether there needs to be a change in the IEP. You can ask for a manifestation determination review. So there are times when a manifestation is triggered, but you can also request one. You can also tell the school that you are not going to pick up your child unless it is a suspension. And if you do pick your child up, so the school is calling, say every day at 2 because your child is having behaviors, you can request that it be marked in the disciplinary records as a suspension. So, and the reason you would do this, sometimes parents will think that the school is doing you and your child a favor by not coding it as a suspension, by not saying this is a suspension, because parents might be afraid that it will be on their child's record or it will reflect poorly on them. But really what is happening is that your child's behaviors are not being addressed. So your child, say, at 1 o'clock every day has ADHD and some other disabilities and is getting overwhelmed and picking fights or throwing things, let's say it's a behavior. And your child has an IEP, but what's happening is every day you're getting a call to come pick your child up. So that means, and it's not coded as a suspension or anything in the system. So what that means is that, number one, your child is not receiving instruction. So they're missing out on instruction. There is nowhere reflecting that they're missing out on instruction and how much time they're missing. And no one, so the psychologist in the school, the counselor, the teachers, no one is addressing that behavior that is causing the student to be removed, basically informally. So it's going to take a longer time for that to be addressed. Even though, it may go on their record, hopefully it'll be addressed. Appropriate supports, accommodations, modifications will be put in place. So it won't become an issue the next school year and the next school year, so that it can be addressed at the time that it begins.
Right, and really important, right? Because these procedural safeguards, right, the MDR, it doesn't kick in until that 10th day or until the 11th day, actually, because it's more than 10 days. So if there's no suspensions on the record, or no suspensions listed anywhere, even though that student has missed hours upon hours upon hours of education, because the school is asking the parent to come and pick them up early. That's doing a huge disservice to that child, and the school has a responsibility under the law to address that, and they're getting around it by not coding them as suspensions or by not putting that on there.
And it's also putting a lot of pressure on the parents or the grandparents or the foster parents to basically take off of work or, change their day to come pick the child up when there is nothing in place to start addressing whatever is happening in the school day. Sorry, something happened in my, there we go. And we wanted to look at how this might affect students, because we talk about the parents, the family, and the school, but how are discipline measures affecting the actual students? So we'll just take a few brief minutes to watch this.
Students are the ones going through it. Like, we're constantly getting kicked out of class, we're getting suspended, we're getting referrals for things that may not be our fault. It's failing us. Like, if we're here to learn, if we're not being able to, if you're not being able to teach us and we're not being able to learn, that's like failing us. Like, if you're suspended, a lot of teachers won't give you the homework that you need to, from the stuff that you missed. We're constantly getting pushed back and falling into the school to prison pipeline. Like, we're becoming a statistic, and that's not what we want to be, not in a good way. Like, we're becoming the X% that's getting suspended and expelled and pushed out, and we don't get to be taught and actually learn. A lot of students, like, because came late to school, that's like, you know what, I'm late, I'm just not finna go.
It's pushing you further away from graduating. Like, you missing a lot of days, then you have to come in and make up work, and then you off topic.
I've got suspended for a fight that I wasn't even a part of. It puts a lot of stress on you.
I had got punished for not wearing a tie to school. It made me feel like, why am I even bothering coming? Like, if you're just gonna send me home based on the ties. It just made me feel like pathetic.
It's frustrating because nobody digs deeper into it. It's like, oh, I'm worried about, I have all this other stuff on my brain. I'm supposed to focus in on the class.
I've been in the 9th twice and the 12th twice. I have surgery on my spine, scoliosis. I'm still going under surgery. They trying to just straighten my spine out with a cage and rods, and like, I don't even supposed to be walking, but like, I'm trying to make an effort to just go get my education.
You want to be able to be comfortable in your school, like, because you have 1,200 officers at your front gate. You may be physically safe, but emotionally you're not safe. Like, you feel completely uncomfortable.
Make your school safe. Make people feel like they want to be there. Sometimes it hasn't been easy for me to go back to school after being in situations as far as fighting and stuff like that.
I think restorative justice practices are really important. Like, it's been proven that they work.
I think that they need to sit down and actually talk to the kids and figure out what's going on, and, you know,
students are the ones going through it.
Sorry, we had a little technical issue there. So it was almost at the end.
Students are the ones, don't just listen, do something about it, like, take it back and utilize it properly, and it does matter because I'm the one being affected by it. Students are the ones going through it, like.
Sorry. All right. All right, trying to move it on. There we go.
So just briefly, because I know that we are over time, and thank you all for sticking around. So in addition to all of what we had talked about, there's also the issue of when police get involved, and then when there's involvement in the criminal and juvenile justice systems, and that could result in no contact orders at schools. There's also the possibility that school punishment could be imposed for outside police contacts or arrests. And generally, what that is for certain offenses, the schools receive what's called an attorney general's report, and it will identify the student behavior and things. And then the school then has the option to take action on their own regarding what had occurred outside of school. And that has, several different, lots of issues, right? For students being punished in school for things that happened outside. And then just always make sure that your child's defense attorney is aware that they have an IEP, or that they have or that they receive special education and related services. It goes a long way into potentially looking at mitigating factors, and could provide more information to the judge or the whoever's in the process, the judge in family court, or in superior court if they're being charged as adults. It's important for the attorney, the defense attorney, to have that information to better advocate for your student. And also more information for the court to consider. And just one note also, in the video, one of the students had talked about being suspended because not wearing a tie. I know that's something that here in Delaware we're looking to, that violations for like dress not necessarily lead to exclusionary discipline, so suspensions or expulsions, and more of something in school, something to just have a conversation with the student about, because just because a student is not wearing the right shirt should not necessarily mean that they should be excluded from the school environment. And I know that that's something that the Delaware is working on, at least the Department of Education. So a review of our learning objectives, identify how disciplinary removals differ for students with disabilities. I think we did that. We got the 10-day rule. What constitutes a change of placement? We talked about that. Change of placement is greater than 10 days from the least restrictive environment. Some of the effects of disciplinary removals on students. We saw that video. And then recognize instances of informal removal.
So here's our information again. Again, this presentation is general information. It's not intended as legal advice. Every person's situation will be different. If you have a situation with a child, with one of your surrogate students, with a foster child, please feel free to give us a call or an email, or visit our website at pickofdel.org, or Classy, the Disabilities Law Program, at declassy.org. And their numbers are there as well. And next week, we will be talking in more depth about the manifestation determination review. So please register for that if you're interested. And this information will be available in our video portal. And if you want the slides, just send me an email, candrews@pickofdel.org, and we can send you out a PDF of the slides. And thank you so much, Stephanie and Jackie. This presentation, next presentation, will also be available in Spanish. So if you have friends, colleagues, parents that you know that speak Spanish and would like to participate, please feel free to send this information to them. And also anybody else that you think might benefit from hearing it.
And please complete the survey.
Yes, that gives us a lot of information, and we use it to help make our presentations better. So thank you. Have a great day.